today's program titled Danger Construction Site, Construction Safety Law Overview 2020. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I'd like to turn it over to Adam Young. You may begin.
All right. Good afternoon, everyone. My name is Adam Young. I am an attorney here with Seyfarth Shaw in the Chicago office with the Workplace Safety and Environmental Group. I have Brent Clark on the line, who's a co-chair of our group. And this slide is not advancing. One second. Today we're going to talk about construction safety law. I know that everyone has been overwhelmed with COVID-19 related questions. We did plan to do this presentation and talk about what was happening up to the COVID-19 crisis, but because obviously that's such a pressing issue for everyone, we're going to be addressing that throughout the presentation. It's unclear from federal OSHA exactly how they're going to change their inspection priorities moving forward. Given the COVID-19 crisis, we can tell you, what we've seen and what we expect moving forward based on the guidance they've given so far. There is still no head of federal OSHA. Since the Trump administration took over, they put forward a nominee to be the Undersecretary of Labor that's going to head OSHA. That person was never confirmed and then withdrew his name from nomination or from consideration. So we have no head of OSHA moving forward. And what we've been seeing across the country is a lot of different approaches from the lifetime bureaucrats. And in different regions, we're getting different outcomes. It may be in response to COVID-19 that different area offices take different approaches in terms of what they're going to be doing and what they're going to be focusing on. All right, so the first thing we're going to talk about is OSHA liability and give folks kind of a general overview on the line. There's 30,000 regulations under 29 CFR 1926 that govern construction. There's also a general duty clause under OSHA, so that requires every employer to provide a workplace that's free from any recognized hazards that are likely to cause death or serious physical harm. And that applies to all employers. That applies to construction sites. So in a lot of instances, federal OSHA, if they don't have an applicable federal regulation, they will cite employers under that general duty clause. And we'll talk about some of the ways that we've seen OSHA targeting construction employers with general duty clause enforcement. Initially, it was thought of, that OSHA only applied to your own employees, but we'll talk about, the multi-employer worksite doctrine and how OSHA has been using that, and the recent case law on restricting OSHA's ability to use that to cite different employers at work sites. All right. Our next slide is the most. Yeah, we're good. Our next slide is the most commonly cited regulations in construction, and those are, as many of the folks on the line know, fall protection in construction is the most cited regulation by OSHA. Over 50% of all OSHA inspections in 2019 were of construction sites, and we gave you the most commonly cited regulations, and I think this photograph, the individual may be violating all of them or almost all of the most commonly cited regulations, which is one of the reasons why I liked it. But scaffolding, general requirements, one of the ways we've seen new scaffolding citations is under the new Walking Working Surfaces standard. That we've seen citations for mobile scaffolds, which we didn't see to the same extent before. We've seen more ladder citations, fall protection training, which is commonly cited in situations where employers are not adequately training to OSHA's specifications employees, and then eye and face protection. Fall protection is commonly cited for a lot of reasons. first, it's very low-hanging fruit, right? OSHA can snap pictures while they're driving by on a street with a telephoto lens and get people caught in the act. And it's a big area of enforcement also because it's such a serious hazard in terms of substantial injuries and death. So that's a major reason why OSHA has been targeting employers with that, fall protection-based citations and inspections. And I'll turn things over to Brent to talk a little bit about OSHA emphasis programs.
Sure, folks, I'm just gonna stick on this slide for a second and just make a couple of comments. As Adam said, you've got on fall protection. I'll just take that one. Unfortunately, in construction, unlike general industry, a lot of our activities are out in the open. They can be observed from off-site and not observed while someone's in the building. And so the advantage general industry clients have is OSHA has to come and has to announce itself. There's an opening conference, and then they get in and see the facility. And so there's a lot of opportunity for notice, a lot of opportunity to do things. Unfortunately, in construction, we just don't have that luxury for a lot of what we do. And it's just a reality of our world that they can pull up alongside of us. They can go into the building next to us, looking down onto our sites and gather evidence, information that supports violations. And so it's just a world we live in, and fall protection obviously tends to be at the forefront of that, and scaffolds and ladders and other things, because they can be seen from off-site. And OSHA is perfectly allowed to use that evidence against us. What they're supposed to do is, after they make some observations, they are supposed to open an inspection. But their guidance and the courts have given them great leeway on using sort of pre-opening evidence against our clients and you folks. So it's just an unfortunate reality, and obviously the best method is to have your programs as tight and as and compliant as you possibly can. At one point we will talk a little bit about some defenses like the employee misconduct defense, but this gives you an idea of, despite everyone knowing what the most commonly cited regulations and OSHA standards are, year after year these guys continue to appear at the top of the list. All right, as Adam said, I am going to talk about OSHA emphasis programs. And let's see, as the slide in front of you shows, I'm going to divide this into two worlds. There's actually three. There's national emphasis programs, there's regional emphasis programs, and there's local emphasis programs. Emphasis programs are simply OSHA's method of deciding what particular hazards they're going to focus resources on. And the emphasis programs are available, like all things, on OSHA.gov. And the key here is, depending on what the nature of your business is, you should make yourselves aware of what the OSHA emphasis programs are. And that's true at all levels. But on the national level, we've got a couple that are particularly have been around for a while in different versions, different flavors, if you will. And what that means to be on as part of an emphasis program is OSHA is going to conduct some targeted inspections for those employers that it believes has the particular hazard. And so that's just an inspection prioritization. They create lists, they refine those lists, and then they schedule a certain number of inspections, regardless of whether there's been any complaint or any specific information they may have about your operations. You can just, I call this losing the lottery. You lose the lottery, you get on their list, and then they conduct an inspection focusing on the particular issue. And we've highlighted a couple just because of their significance. The first is lead, and lead has obviously been around as a construction hazard for a long time. But one of the keys for these inspections are emphasis programs is they all in one version or another have a trigger that says if a compliance, safety, and health officer, COSHA as we call them, it's an inspector, observes a work site condition that they think implicates the particular hazard, then they are either required to immediately initiate an inspection or they're required to follow a procedure where they start a process with the office to start an inspection. And so knowing that there's an emphasis program for a particular condition or hazard exists helps you identify where OSHA's likely to inspect, and otherwise we don't know when OSHA is likely to inspect. So possessing this information and understanding where your emphasis program, what your activities and what jobs you have with either a local, regional, or national emphasis program is really important from a compliance and inspection response strategy perspective. So, lead, as I said, has been around for a long time. I mean, there are some horrific stories of lead paint removal, that kind of thing, where OSHA inspects the bridge are some of the highlighted examples where they've literally find mass non-compliance, people not wearing their respirators, engaging in proper hygiene and other practices, and literally we've seen some of the multi-million-dollar construction citations with respect to lead and lead removal activities. So just to highlight, OSHA views these as extremely significant, and they're important to keep an eye on. Trenching and excavating, again, for those of you in this line of work, you're well aware, but there has been extremely active enforcement of trenching and excavating standards. In fact, if you look at that NEP, or National Emphasis Program, you'll see embedded within it, it literally commands a COSHA compliance officer to open an inspection whenever they see an open trench. The only exception is if they might be on the way to a higher priority inspection, like another fatality or something of that nature. And then if so, they're going to call back to the office and have someone else sent to your site. Adam, I think you had a story of some activity here in the Chicago area that is illustrative of this, and could you just take a moment and tell folks about that?
Oh, sure. I was at an informal conference at the Des Plaines area office out in Des Plaines, Illinois, and there was an open trench across the street from the office, and I asked the area director about it, and she said, "Oh, we've had someone over there every single day looking at what was going on and taking pictures, because we have to, right? Anytime anyone's walking by on the sidewalk, someone needs to be looking into this open trench." So if you're operating near an OSHA area office or on the route to or from an area office, you may get a lot more activity from OSHA.
Yeah, that actually is a little strategy point for your jobs. It would not, and if you know you're going to be trenching and excavating, it's not a bad idea to map where the local OSHA area office is, and get a sense of, are you nearby? Are you on a path that folks may take to be going out on inspections, that kind of stuff. Again, primary emphasis here, of course, is on, compliance as much as possible. But in terms of preparing yourself for likely OSHA inspection and investigation, it's just something to take into account. Last one on the national level we wanted to highlight for you guys is the crystalline silica or respirable crystalline silica, RCS, as it's known for shorthand. On this one, we'll get a little bit of new information. There was an updated NEP on this that just came out last month. It didn't really. There's been a NEP on silica for the last several years, as you folks are probably well aware. But the updated NEP is worth a read. It's not that long. One of the interesting things about it, and we're still sorting it out, but most NEPs have an outreach period. And what that means is there's a period in which the OSHA does outreach to the affected industry. In this case, for the updated crystalline silica for construction, it's a 90-day outreach period. And if you read it very tightly, what it means is they're not supposed to begin enforcement under the NEP for that during that 90-day period. I caution folks to, I don't believe this is a carte blanche because all NEPs contain a provision that says if a complaint is made, perhaps by an employee that relates to the NEP, that typically trumps and will trigger an inspection. And in any event, OSHA, I think, always possesses discretion if they want it. To what it means, I think, practically speaking, is you're not going to get a scheduled NEP inspection on crystalline silica until that 90-day outreach period. And frankly, it takes them a while to resort which companies are covered anyway. The last area I'll touch on here real quick on local emphasis programs. These are exactly what they sound like. This is where either some subset, small, a region will, or even a local area office will implement an emphasis program. And so they're very similar than the national emphasis programs, but their jurisdiction geographically is narrower. They typically, LEPs typically have a sunset provision. They can be a year, another defined period of time. So those tend to cycle through faster. But again, you can be in an area where they have an LEP, and you could be in an area you might have a job, 100 miles away or in the next state over, and it won't have the same emphasis program. So some that have been kicking around and are alive and well in various jurisdictions are, roadway work, zone activities. So if you're involved in any aspect of construction, it's good to double check, know your emphasis programs and plan accordingly. And again, of course, fall hazards in construction. These we're just seeing in various ways. I can tell you, in our experience, any complaint that is made to OSHA for fall hazards is going to get priority in terms of inspection resources. Obviously, the hazard is, very high because it could result in death, and they prioritize based on the severity of the hazard. So anything, we call it IDLH, immediately dangerous to life or health. Anything that's an IDLH hazard is going to get a higher priority for OSHA inspection activities. Again, that doesn't mean they keep doing their same stuff, but that's the world we live in. So just some tips on what you should know about and on that front, and then I'm going to take us now to the new kind of penalty structure real quick. And Adam, this is for me as well, right?
Yeah, sure. Go ahead.
Okay, great. So this is pretty simple, folks. I've just got the revised penalty structure slide up in front of you. I've been practicing OSHA law for, I have to say, 35 years. So I've been around for a long time. Not quite since the beginning of the act, but there's a lot of water under the bridge. The penalty structure for OSHA was rather stagnant for a while, but several years ago, during the Obama administration, the penalty structure was changed and it essentially was adjusted to bring it current for cost of living, and then it has been made actively to automatically increase per the CPI, the Consumer Price Index, every year. And so what that means is the penalty structure has increased and will increase every year as long as there is inflation. So we are now up to $13,494 on other than serious and serious citations as a maximum penalty. That doesn't mean that's what you're going to get, but in the old days, those of us been around a while, were used to the old $7,000, and so essentially, we're almost up to twice what a serious or an OTS used to be. Obviously the numbers have gotten really high on willful and repeat. Those are now running at almost $135,000. And again, that doesn't mean that's what you're going to get. OSHA will follow its penalty policy, but the stakes have gotten very high. These are single citations, folks. It's just one. You can, and so it's not uncommon for us to see, citations in the $70,000 to $100,000 range, where OSHA thinks they've given you a break, believe it or not, because they've adjusted down the various penalty factors and not hit you with a max on everything. But that's a different world, and just in terms of materiality and significance for the business, if it's a higher risk, and when you're presented with higher risk, you should allocate your resources accordingly in terms of compliance and training and all that stuff. So most of you are aware of this, but again, it's going to keep every year. It'll go up as long as we have any inflation. And then we've got failure to abate. And Adam, if you don't mind, because I know you have a rather crazy case going right now on failure to abate, could you just give the folks a couple of general comments on how failure to abate works?
Yeah, sure. So failure to abate is the cardinal sin in OSHA. We have a case going now where an employer who we did not represent at the time in 2018 received 4 pretty minor citations with a total penalty of something like $13,000. They didn't contest the citations. They didn't abate the citations. OSHA showed up in 2019, did another inspection, said, look, none of these 4 minor citations have been abated. And they issued a citation for $1.25 million for failure to abate. And that was just 45 days of a combined penalty at $13,494 per day per citation. So they can add up, really quick to get to these huge numbers. If you ever get contacted by OSHA about abatement documentation or missing abatement documentation, you need to get in touch with them right away and make sure they get that, because OSHA doesn't want to do failure to abate inspections, and the penalties can be quite egregious.
Thanks, Adam. And I'm gonna kick it over to you for the next slide, if you don't mind.
Sure. Yeah. So we talked about that OSHA used to traditionally be thought about as something that applied to your own employees, but OSHA now is going to look at the worksite very holistically, and we recommend that employers do that too. Since 1999, OSHA has articulated that holistic approach in something called the multi-employer worksite doctrine, where they'll assign liability for any employers at the worksite who fall into different categories. They talk about those employers as the creating employer, the employer who created a hazard, like digging a hole, for example. the exposing employer, the employer who directed their employees to go over near that hazard or to work with that hazard, the correcting employer, so the employer whose job was to fill in the hole, that they have that authority or that responsibility at the work site, and finally the controlling employer. And OSHA typically tries to use the controlling employer liability for general contractors or host employers at a work site. Liability can involve citations against any of those four types of employers at the work site, and it could be, there could be 17 employers at a work site, and all could be cited by OSHA for the same accident or the same alleged hazard if OSHA believes they fit into one of those categories. OSHA citations are civil. You could be civilly cited, but there's also criminal liability as to employers, and that could be any of those employers who are cited. And we'll talk about criminal liability in more detail, but if there is a willful citation that's alleged and there was a fatality, there's potential criminal liability. Also under state statutes. So we know the New York State, for instance, is very active in prosecuting reckless endangerment cases against employers in different types of industrial accident situations. In terms of the different categories of employers that could be liable, I talked about the general contractor. That could be a liability for hazards or conditions at the work site. There's also different subcontractors, leased employees, temporary employees, consultants. Those are all different employee types that are at the work site, and they could be the basis of OSHA citations. OSHA has a temporary worker initiative where if there are temps that are on a work site, they are going to zero in on them, figure out about their training, ask questions, and potentially cite employers because they believe that temp or borrowed employees are going to be more likely to be exposed to hazards than other folks. All right, so we have many defenses to OSHA citations, and one of the ones we talk about most commonly with construction employers is the specialty contractor defense. It dates back to the 1980s with case law from the Occupational Safety and Health Review Commission. And essentially it says you can reasonably rely on a specialty contractor to perform work in that area of specialization in compliance with OSHA regulations. To give you the most basic example, they have a standard interpretation about a homeowner who's not in the construction business that hires a roofing contractor. And they said, well, am I liable for the OSHA violations of the roofing contractor? And the standard interpretation said, no, you wouldn't be because you're reasonably relying on that roofing contractor to comply. But a construction company is more sophisticated than a homeowner, and they're held to higher standards. And you're going to be expected to only reasonably rely on a specialty contractor. So OSHA is going to look at, is that subcontractor, do they have the expertise and history that makes them a specialty contractor? Do they have knowledge and experience? Do you have prior experience working with them in the past? Are you aware of on-site non-compliance or safety issues in the past? Had they used a crane unsafely at other work sites that you had, and what had you done about that? And are you doing the reasonable quality or safety assurance to make sure that they're doing the work safely, meaning the specialty contractor? We've seen a couple cases addressing the specialty contractor defense. The most recent was at the D.C. Circuit and in Manua v. Scalia, which was a case out of American Samoa. That case distinguished prior case law on specialty contractor and said, well, this cited employer, they brought in a crane contractor, and that crane contractor hit power lines, electrocuting 2 employees. And they said, look, the court looked at the general contractor and said, did you reasonably rely on the crane contractor? And the court found that they didn't because the general contractor had also provided employees who were working there. They hadn't created an exclusive zone for the crane. They hadn't taken into account that there were power lines there. They said there wasn't a lot of prior experience with the crane contractor, and they didn't have sufficient basis to reasonably rely on the specialization of that crane contractor. So it was an important case in that it showed you kind of the limits of specialty contractor and the benefits of doing your homework ahead of time to make sure that someone is truly a specialty contractor and to the extent that the employer was involving its own employees in the process, it had to make sure that its employees were properly protected. Another case that we highlight here is Suncor Energy. This wasn't actually a specialty contractor case per se, but to give you a little sense of the facts, a host employer who operated a huge facility brought in a subcontractor who was going to work inside of a confined space. And in that confined space, the subcontractor brought their own fall protection equipment. Folks who were doing the work didn't hook up that fall protection equipment, and one employee fell something like 12 feet to being seriously injured. And the Occupational Safety and Health Review Commission rejected OSHA's citation of the host employer. And the commission said that the host employer had met its duties in that they had a program in place. They'd alerted the subcontractor of potential fall protection issues in there in the confined space. And the commission said you can't have a scattershot approach where you come and just cite everyone, and that a host employer or a general contractor is going to have a lower level of duties to protecting the employees of a subcontractor than the subcontractor would. So it wasn't a specialty contractor case per se, but it addressed the same issues and reined in OSHA's scattershot citations of all employers at a work site. So we talked about...
Before you move on, I'd just like to interject real quick. You know, the multi-employer worksite doctrine is kind of one of the bane of our existence in construction, because in many respects it might feel like it's, you know, OSHA, it gives OSHA tremendous discretion and they can pretty much cite anybody they want. That may be their practice, and Suncor is a perfect example of their practice. They, especially when there's serious injuries, while the injury theoretically should not drive any OSHA citation, the hazards are there or they're not there regardless of whether there's been an injury. But OSHA clearly, in our experience, is reacts to serious injuries, and there's more serious enforcement, more harsh treatment with serious injuries, somewhat undeniable. But this is a perfect example where you know, the company had appropriately relied upon the expertise of the subcontractor and had some basic due diligence in place, and had no way of knowing on the particular day in question that the employee had not tied off. And frankly, because it was a confined space, there was no sort of common view. You know, the employer was not, and the host employer was not authorized to enter the space as an entrant, and couldn't do so in compliance with the permit required confined space standard anyway. So this is an example to keep in mind that even if you get some rough treatment under multi-employer, we really recommend you talk to your attorneys and figure out that, because you may well have defenses. We live in a world that just because OSHA says it's a citation and believes it's valid, we live in the world where we say, yeah, not so fast. So anyway, just a couple of comments on that, Adam, and I will push us forward to the next slide.
Well, thanks, Brent. You know, in terms of preventing OSHA citations on the front end, we do recommend having a contractual rider that defines responsibility for safety and health compliance, and who's going to be doing training at the work site, who's going to be doing site-specific training, who's going to be providing the personal protective equipment. By having that contract or that rider to the contract in place, it defines responsibilities, and it may delegate some responsibilities onto a subcontractor or onto a specialty contractor that's being used. As we discussed, you may want to consider whether you are exercising control over the means and methods of a specialty contractor or of a subcontractor, because if you are there supervising their work or providing employees to work alongside them, there may be heightened duties, and the specialty contractor defense may not be applicable. So that's something to think about. And obviously, we recommend training. Every employee is going to be at a work site that they should stop work immediately if there is an imminent danger. And that would apply to our employees. That would apply to subcontractors. even if we're not doing daily supervision of a subcontractor's work. If we have a manager on site and that person observes an imminent danger or something that needs to be stopped immediately, that they should do so.
Great. Hey, Adam, do you want to go ahead and give the CLE code?
Sure, it is SS2318. So just to repeat that, that's SS as in Seyfarth Shaw 2318.
Great. Thank you.
So prior to COVID-19, what are we seeing in terms of aggressive enforcement? Brent, do you want to take this slide?
Sure, happy to. And just as a comment, we're not really seeing COVID-19 enforcement just yet. It's too much on the front end. I will comment that OSHA did put out a guidance document just last week on COVID-19. If you haven't seen it, take a look. It again is available on OSHA.gov. It basically instructs employers to implement a classic sort of hazard analysis, hazard prevention plan. Different levels depending on the community or type of work you're doing. But it's out there. Just highlight for you folks, there's a special guidance document issued last week. It largely follows the CDC and the WHO. Adam and I happen to be members of our COVID-19 task force and have been working on this since it first appeared. But that's a document you should look to. Again, you may want to take some action depending on what kind of programs you have in place. On aggressive enforcement, let me just get there real quick. Sorry, folks. There we go. I'll just say a couple of words here. As Adam mentioned at the beginning of the program, we are seeing varied aggressive enforcement depending on where you are in the United States. And it's not either just Fed OSHA or state OSHA programs that one or the other that are aggressive. We're seeing aggressive based upon particular area directors. We're seeing aggressive based upon particular OSHA inspectors, in part because there's not a lot of federal Washington, D.C. level control over OSHA in the absence of an administration appointed head of OSHA. So anyway, it's very spotty. It depends on where you work. But one of the things we've seen is use of interpreters. They're bringing interpreters to the work site in advance, being very aggressive about conducting interviews in primary languages like Spanish, for example. OSHA has continued its emphasis on repeat citations. And repeat citations, just to remind everybody, are the same employer, the company, received a citation which became final within the last 5 years. So that 5 years tail is really significant. And the particular work site you're working on at the time doesn't have to have known about that previous citation. It doesn't have to be the same management team. If it's the same company, the same employer, you are subject to repeat citations going back 5 years. And OSHA is using this very, very aggressively. It's been an important part of their citation strategy for over 10 years. And because it's not a willful, there's no knowledge or intent involved in that kind of citation. Another thing I just wanted to touch on, and then I'll kick it to Adam, is requests for root cause analysis in company insurance audits. This kind of falls into the category of no good deed goes unpunished. Obviously, for the safety professionals in this world, we want to do root cause analysis on accidents, near misses, things of that nature. It's a way we enhance our safety program. OSHA, unfortunately, does not recognize a privilege to root cause analysis. There's an old guidance document out there on what we call self-critical analysis. And it just basically, at the end of the day, says if OSHA feels it's relevant to their inspection, they can ask for it. So the cautionary tale here is, especially on your significant incidents and injuries, you want to be cautious. Obviously, root cause analysis needs to be candid, but you want to be very careful because those can become exhibits in your next willful or repeat, should OSHA get their hands on them, and there's really no privilege. The other thing is company insurance audits. So if you bring on your insurance company to do audits of your workplace, this is not well understood, but those audits are not privileged. They do not, there's no legal privilege that attaches, and aggressive inspectors have gone after them. They can subpoena from us. They can subpoena them from the company themselves. And so now you've got your insurance company being required to turn over audits that they've done on your work site. And a lot of times we see insurance audits and we kind of, we look at them and go, well, that wasn't quite right, but we don't close those out because we know they're not right. Unfortunately, what that leaves is a paper trail of an unaddressed, unrebutted allegation. So just a practice tip here, be very careful about your insurance audits, and if you think they got it wrong, at a minimum you want some sort of internal document or memo to the file which kind of lays out your response, because we've seen audits, be used in some of these bad cases to the great detriment of our clients. Continuing on aggressive enforcement, just let me advance that slide. Sorry, folks. The employee-by-employee citations, we call this egregious. This is the egregious penalty policy. This is a pure creation by OSHA out of whole cloth. It's not in the statute, it's not in the regs, but it has been upheld by the courts. And essentially what this means is each OSHA could decide if they believe there's a willful violation to cite for every specific employee who was exposed to the hazard. We've given you PPE and fall protection as examples. That would normally what OSHA will do if you got 4 or 5 folks not wearing head protection or foot protection on a site, you get 1 head protection citation, you get 1 foot protection citation, and then you'll get multiple employees who are not wearing. Under the egregious or employee-by-employee citation policy, this gets ramped up, and you get a separate citation for each employee. And at close to $134,000, $135,000 a pop, you don't need many employees before this is disaster from a penalty perspective. So, if you're ever in an inspection and you get any hint that OSHA's looking at willful, you want to keep this in mind because you're going to want to go into heightened inspection management to do everything you can to cut this off. As part of the aggressive enforcement, we're seeing use of the general duty clause, workplace violence, arc flash, arc blast, heat illness is a fairly hot topic, especially in construction. Pardon the pun. And OSHA, we're seeing more and more aggressive enforcement. I have a case from last summer. Obviously, these typically arise during the warmer seasons, but the company had a very thorough heat illness protection program in place. Employees were trained. It was emphasized every morning at the start of the job, and an employee did not disclose symptoms until halfway through the day. And by a few hours later, he was receiving treatment. but nonetheless, OSHA second guessed the company's response. So from the outside, we'd look at that and say that was a perfect application of a heat illness prevention program. But again, OSHA, when they get aggressive, and that's the point of this little discussion, is they can take some pretty extreme positions, and now you're on the back end of citations. All right, Adam, I'm going to kick it to you.
All right, so the revised record-keeping rule. This will be potentially impacting employer policies. Those of you who have followed this at all, I don't need to give you the whole saga, but there was an updated record-keeping rule at the end of the Obama administration. There's since been some explanations from the Trump administration on a few topics. One is incentive programs. Incentive programs are lawful. There are some guidelines. If you have an incentive program, you have to have counterbalancing measures to encourage reporting of injuries and illnesses. The Obama administration preamble to certain rules had also had drawn into question certain drug testing policies as to whether those would be lawful. The Trump administration has clarified that post-accident drug testing is lawful so long as the employer tests each employee whose conduct could have contributed to that accident. So if you have a work site where someone's hit with an operational truck, a pedestrian's hit with a truck, you don't just test the pedestrian who gets injured, you also test the driver of that truck. We do a lot of policy work on drug policies. If you have a post-injury drug testing policy now where you just test the injured employee, that's probably not lawful. Give us a call. We can help you update it. In terms of employee literacy challenges, we have seen OSHA be much more critical of employers on training and cite them on training if employees are unable to articulate what they've learned and if they can't understand the training that they received. So the average American now reads apparently at the 4th grade level. OSHA is very critical that training needs to be understood by employees. So we recommend using pictures, using visual aids, having someone there to answer questions. If you just do an online training module without having someone there to answer questions and maybe drawn into question as to whether that training was adequate. The same would be true in terms of native language. If an employee receives operational instruction at the work site only in their primary language, only in Spanish or only in Polish, they should probably be getting training and safety training and instruction in that native language as well. And OSHA has been critical as to whether employees are properly trained who don't speak English as a first language. As Brent said, they're bringing interpreters onto work sites, and they're interviewing employees in their native language. So if those employees can't articulate training or don't articulate they understood training, you are at risk of potential citations. Where OSHA has been very aggressive and probably over its skis is saying that employers need to have all their policies in all these different languages, and that's not accurate. We've pushed back on that. We recently one of our clients received a citation for not having lockout-tagout policies in a dialect of Burmese that was spoken by employees. And when we did our internal investigation, we learned that there were 27 languages among the authorized employees at this facility. There's no requirement in OSHA to translate all your lockout-tagout programs into 27 different languages. You just need to make sure that employees are properly trained and understand the policies and the procedures. All right, Brent, did you want to talk a little about criminal law liability?
Yeah, I'll make this brief. I've got the slide up here. Criminal prosecution is rare in OSHA cases, but it does exist, and it's part of the act. As a practical matter, every single fatal accident that occurs at the federal level is examined for potential criminal prosecution. We talk to the head solicitor, the head attorney for OSHA every year, and we get told this every year. So fatality is obviously a key trigger here. The fines, you can't put a company in jail, so the 6-month imprisonment means for managers. And what we do see is that a lot of times OSHA will work with, and it'll get referred over to a state prosecutor who will use reckless endangerment and other more state state-oriented prosecutions about to affect this, because it's harder under OSHA. But I personally in my career had 2 significant OSHA criminal prosecutions, and I'm happy to say that neither of those clients ended up having any type of conviction. In fact, they were withdrawn. The irony of both of those criminal prosecutions against the company is it was ultimately discovered that it was murder by a coworker, who one was gang related and one was a love triangle. But in one case, it took 3 years and a jailhouse snitch to discover what really happened. So criminal law is out there. It's obviously very, very serious. So keep an eye on it. In all fatality inspections, you should start off, making sure you get proper advice for that stuff. This next slide just simply covers some of the stuff I just chatted about. Lying to a federal inspector and falsification of records are the other ways we see criminal liability. There's some notable cases out there where folks fall to their death, and then the foreman, puts a harness and a lanyard in the guy's truck, and just bad stuff that we know you folks would never do. So it's out there, and you need to know it's out there. That's about that. Adam, I'll kick it back to you.
Yeah, so in terms of the elements, what are the elements of an OSHA citation? You got to understand that, from the outset when you're defending inspections. There has to be an applicable OSHA standard that the hazard existed at the work site, and there has to be employee exposure to that hazard. So that would be reasonably foreseeable employee exposure, not something that's caused by an intentional act of the employee. So it's something that you would expect. If you have an employee that goes through multiple layers of red tape and finds his way onto some ledge to smoke a cigarette and falls off, we would argue that's not reasonably foreseeable employee exposure, and OSHA can't prove its case. And this is before we get to any defenses. The final element is employer knowledge, and that means that this employer, this cited employer, a member of their management needs to know or should have known of the alleged violation. And sometimes we could caution that could be a lead or a foreman, and sometimes that could be a unionized person if that's your on-site manager. So those are all issues that come up in our defenses. But typically, if someone's done something like gone through that red tape, we don't think it's reasonably foreseeable, number one, and an employer didn't know or should have known about it. So that we don't think OSHA can prove its case. And that's kind of a background before you get to the main defense of OSHA cases, and that's on, yeah.
Before we move on, I see we've got a question that I want to just jump back to. Sorry for jumping around, folks, but we got a question on, heat illness and heat illness protection. It's a good one, so I'll share it with the rest of you folks. The question on heat illness is, here you have inspectors who, in our area, they go to the training institute in Arlington, and they get, they're being trained, on everything in a very quick period of time. And they're not exactly experts in heat illness or heat illness prevention. And remember, they're safety and health officers. They're not medical professionals. They're not paramedics. And so you've got them wading into a rather complex health issue when you start to deal with heat illness. And heat illness is complicated by the fact that it's very individual. It's like ergonomics and musculoskeletal disorders, very individual. And so from a regulatory perspective, they've got a blunt instrument. They're using the general duty clause, and they're trying to second guess typically what an employer has done. These are fertile grounds for defense. Even if an employee has, experienced heat illness, as long as the employer steps along the way are reasonable. There's two significant cases. Our firm, our group, actually handled one of the seminal cases on heat illness prevention a few years ago here in the Chicago area. It was an exceedingly long trial before the chief OSHA judge, Judge Rooney. And unfortunately, we had to take it to trial, and it was very complicated. It was a very costly defense, but we won, despite OSHA bringing all its resources to bear. The case I mentioned from last year where they second-guessed is ongoing. So that one we don't know, but we certainly believe we've got great defenses, and we're in the process. They're just messy to defend. So anyway, just wanted to catch us up on one of the questions we've received and remind folks, I know we're getting towards the end of the presentation, but if you do have questions, let us know. All right, Adam, you want to continue on?
Yeah, sure. So just real briefly on the employee misconduct defense, there's 4 elements to that, and one of them that say you have the safety rule, you train employees on the safety rule, you supervise, and then you enforce any violations. And where a lot of employers fall down is that they don't do that enforcement. So, they have the training, they have the safety rules, they have people who are competent persons doing frequent and regular inspections, but they don't have enforcement. I included some documents and in parentheses on this slide. You don't have to have most or all of these documents, right? It could be an unwritten rule, it could be unwritten training, you could do undocumented supervision, and you could have no records. But the more records you have, the easier it is to present the unavoidable employee misconduct defense, both during the inspection or after you get a citation, and the easier it is to prove. But if you have situations where people are violating safety rules, you really need to be enforcing your safety rules. That may be discipline, it may be not using a contractor, it may be communications with the contractor, telling them that they need to take certain actions to deal with that. So in terms of generally, we were also going to talk about reducing the risk of OSHA citations, focusing on the cores of your businesses. A lot of employers don't understand the reporting rules. If you have any reporting questions, give us a call. If you have a fatality that needs to be reported within 8 hours, if you have a workplace incident that results in amputation, loss of an eye, or medical treatment, hospitalization for medical treatment, then that needs to be reported within 24 hours, but only if those incidents take place within 24 hours after the workplace accident. One way to prevent OSHA inspections is not wrongly reporting something that's not reportable. If you report something as an amputation 2 weeks after the accident occurred, maybe there's a 75 or 100% chance that OSHA is going to come and do an inspection of your work site. And it may be you're reporting something that's not reportable. So make sure, if you have any question about those rules, give us a call, and we'd be happy to answer any questions. In terms of participating in responding to OSHA, obviously we want to be truthful. We don't want anyone being criminally prosecuted for providing false information for OSHA, and also a lot of times after accidents, if people are speculating or guessing, they may be giving false information inadvertently. And we don't want OSHA to run with false information that they have, which may result in unfounded or legally and factually inaccurate citations. We also have more slides here, and this will be available on our website if folks are interested in terms of how to manage an OSHA inspection. In terms of planning ahead of time, I'm trying to advance the slide. I'm not sure who keeps backing it up.
I got it.
Okay. But those would be developing those defenses ahead of time, blocking and tackling, having your plan in place, how you're going to deal with OSHA inspection, who's going to be your point person, who's going to be taking those comparable photographs. If you raise concerns at the opening conference, you limit the scope, you're less likely to have an expansive inspection and maybe more limited to an accident or a specific location at your work site. And there's a lot of benefit in doing that. Brent, do you have any other comments before we have to sign off here?
No, just on inspection management, my general comment, having been doing this for a long, long time, is that the number and degree of citations you get is not determined when OSHA shows up. It's not a fait accompli. Just because OSHA's there and is about to examine your work site, there is a tremendous amount of risk management that can be done through proper inspection management. And all lawful, all appropriate, all, just exercising your rights. Your rights to be present, your rights not to be disrupted, your rights to have representation of foremen and managers when they're interviewed, the rights for employees your right to debrief an employee, do your own investigation after the fact, and then head off OSHA if they're heading in the wrong direction, or at least clarify for them. So inspection management, I can't emphasize as a practical matter the fact that you can dramatically reduce your risk and dramatically reduce your exposure by properly managing your OSHA inspections. So if you don't have some programs and procedures in place on how to do that, we recommend it. We recommend that you talk to your attorneys to get advice on how to do that, because there's a lot of rights out there that people don't realize they have. And just because OSHA shows up doesn't mean it's game over. So I'll close with that.
All right, well, thank you all very much, and feel free to contact us if you have any questions or concerns. We have significant resources on a blog that provides information on updates on environmental health and safety matters on a multi-time-a-week basis. So feel free to email me or Brent. Thank you very much.
Thank you. Thank you so much, and thank you for taking the questions. If you do have any additional questions, you can certainly put them in the chat box, and we will certainly respond to them. So this concludes today's webinar, and we thank you for attending.